Welcome to Criminal Law Unfiltered.
Welcome to Criminal Law Unfiltered with Robert M. Helfend. Robert is the founder of Helfend Law Group, and for over 4 decades, he's defended thousands of clients facing serious state and federal charges. I'm Leanne Lyon, and in this episode, we're looking at how federal drug cases are built in court, from the evidence prosecutors rely on to the decisions defendants face about cooperation, sentencing, and strategy. This is Federal Drug Charges Part 2, Evidence, Cooperation, and Sentencing. Robert, what kind of evidence do prosecutors usually rely on in federal drug cases?
Good evidence. How about that?
Oh, there we go. We're on to
There
the
it
next.
is. That's all there is to it. Normally, the evidence that they rely on is, first of all, they have to have some sort of a seizure. So they have some drugs, right? They seize some coke, or they seize some cocaine, that is. They seize some methamphetamine. Maybe they seize some fentanyl, any kind of controlled substance. And it has to be a Schedule 1 substance, which drugs are delineated in the United States by schedules. So Schedule 1's drugs are the ones you would normally associate it with the most serious drugs: heroin, methamphetamine, cocaine, fentanyl. But that leads me to one more thing. Marijuana is still a Schedule 1, which is quite amazing.
That is
So,
pretty amazing.
yeah, marijuana should, every year you hear rumors that marijuana will be taken off the Schedule 1 designation, but it just doesn't happen. Anyway, so there has to be a seizure of some kind, and then what normally happens is the federal government gets people's phones, and then they'll get a warrant to record phone calls, and then they will follow the phone calls, follow the transactions that they find on those phones, and then they'll normally serve search warrants and get some more drugs, and then they will normally, once that happens, a lot of people will get lawyers and then call the U.S. attorney that's involved in the case, and they will essentially contact me or the person's lawyer and see if your client is willing to come in and talk about the case.
Mm-hmm.
And that's where that cooperation comes in. Now, people who are first-time offenders, they don't have to do that. They don't have to come in and talk about the case with them prior to being something happening, like being indicted, because there's something called safety valve, and safety valve in federal court means that if you just come in and admit what you did, it's a limited cooperation. But safety valve allows the court, the judge, to get under the mandatory minimum that you're facing. And once you can get under the mandatory minimum, then the judge can utilize what's called 3553 factors. 3553 factors, that's a code in the U.S. codes that allows the judge to sentence based on your individual characteristics of you. Are you working? How long have you worked? Are you married? Do you have kids? Do you have any prior convictions? What have you done in the community? And is this an aberration? I have something like that going on right now, where this person was involved in a drug conspiracy, and for really about a month, and they're offering her a plea to a non-mandatory minimum sentence, so that's good. But the judge is going to utilize the 3553 factors in that case to decide what is appropriate. And the fact is that this client was, involved for about a month. Why did you do that? Because this person was desperate for money at the time and was being evicted, and is doing very well right now. And the fact is a felony conviction carries with it enormous disabilities. Just besides the fact that you're subject to possibly going to jail, having a felony conviction is a disability. Trying to get a job, sometimes voting. You definitely can't have a gun ever again in your life, but a felony conviction, it hurts.
Yeah.
So that's one factor I like to bring up to the court, that this person was involved in this case, Your Honor, for a month and a half. Said, I don't want to do it anymore. I realize this isn't legal, so I'm gonna get out of it. This person is going to get a felony conviction, so it's going to hamper this person's ability to get a job in the future. So we shouldn't overlook that. Why don't you just give this person probation?
Yeah.
Did I answer the question?
Well, we were talking a little more about what kind of evidence do prosecutors usually rely on. So besides, you said seizure of actual product would be one of the answers there. But
telephone calls.
Yep.
Then they do search warrants.
Right. Exactly.
And right, search warrants, and then they do more seizures. And one piece of evidence that I didn't mention in federal cases is the testimony of other people, especially people who are links in the chain to the people higher up.
Sure.
So it's a little different federally than it is statewide, because as we were talking off camera, I was saying that, when you go to trial on a case, it's not about the truth, it's about the evidence. And that's it's a different concept.
Mm-hmm.
And federally, though, this is why federal cases are difficult. It's because it's actually more about the evidence in federal court, because the federal government won't bring a case that quickly. They will investigate something for years before they indict. And so it's difficult to defeat that because of the resources they put into it.
Yeah.
And so that's why there's so many plea agreements in federal court, because it's been investigated for so long, and all the loose ends that you could think of, they've already thought about those, 2 moves or 3 moves ahead of you. So,
well, in keeping that in mind, and similarly related, I'm sure, how common are things like wiretap, surveillance, confidential informants in these prosecutions?
Very common. In every one of the federal drug cases or drug conspiracy cases that I've had, they're all everything that you've spoken about are elements of the prosecutor's case. There's wiretaps always, because the wiretap is a very useful tool, powerful tool for the prosecution. That's how they get, like, the tentacles of the octopus. That's how they figure out how extensive this conspiracy is. And and once they do that, that's what we were talking about earlier, is that's when the prosecutors will serve search warrants on those tentacles and get those underlings and put pressure on them to rat out their seniors.
And can that kind of cooperation with investigators result in a reduced sentence, or does it sometimes backfire? And can you give an example?
The reason why somebody would cooperate is because it does help that person in the end at sentencing. What happens is, under the guidelines, there's a provision called 5K1. If you get a 5K1, that means you cooperated with the government. And the way it's handled is different in every jurisdiction.
Okay.
So what that means is, at the time of sentencing, right before sentencing, the government will file a downward departure motion. And when I talk about downward departure motion, I'm talking about recommending to the judge that the recommended guideline range for this person is lower, because the government is making a motion to lower the guideline range because the person in front of the court has given the government substantial assistance. Substantial assistance is a defined term. It means that the person gave the government information which they were able to act on. Either they were able to bolster their case, find somebody else, to arrest or investigate, or help investigate the person that they're looking for. So it definitely does help somebody. The downside to that is, as I thought I spoke about this in episode 1, is, people who are aware of the way the politics works, if you go to, jail, may not want to cooperate because other inmates, this is just the way it works in custody, where, it's a whole another world when you're in custody, right? And it's confined, and they have nothing else to do other than, here comes a new guy, a new person into custody. Let's figure out what their charge was, and let's figure out if they're a rat. And depending on, who knows about it, your life could be in danger. And so it's a very big decision to make, whether or not you want to cooperate with the government. And, the government, I've sat in on these meetings, and I see it more and more and more and more, where people will go to the meeting and refuse to speak to the government because the first thing they will ask them is, what are you going to do for me? I mean, do I have an assurance that my name will not appear in some report? Do I have an assurance that I won't have to testify, in front of the person that you're actually after? And of course, they can't make that promise. They can't, because what happens if, who knows? The person that they're after goes to trial, and all these dominoes fall, and then the government realizes, well, we need now that guy's testimony. And so it's a death sentence for some people. It really is. And the government can't protect you. And they will throw you away like a piece of trash. So if you're it does happen. I have a lot of respect for people who, my job is to make, is to get you in position to get yourself the best or the easiest way through this system and the lightest sentence I can. And so I have an obligation to see, to put you in a position to get this 5K1, because it definitely will help you.
Sure.
I mean, I do have people who are in a situation where they can get a 5K1 or cooperation, and they have prior convictions for sales, so they are facing career criminal status in the federal system.
Mm.
Yet when they get there, they would rather just take their punishment rather than, rat out, so to speak, or cooperate and turn in the people that the government's interested in. It's
So
interesting.
it's interesting, and it does sound like it could be very dangerous. So, is there ever a situation where contacting investigators directly helps a defendant, or is it usually that it will just make things worse, as we've heard?
No, it doesn't make things work. What happens is well, first of all, as if you're the defendant, you would not contact the investigator. So when you say that, I figure you're talking about they get a lawyer, we contact the investigator. What happens when I contact like a DEA investigator is I'm just interested in who is the AUSA, who is the U.S. attorney that's directing you. They don't do things in a vacuum federally. They always have a U.S. attorney telling them what to do. They're involved from day one. So once I get that U.S. attorney's name, then I'm in contact with them, and that's how things get started. That's how we can work out maybe a pre-indictment plea agreement. We can talk about a meeting, a proffer, it's called, and talk about cooperation if that's something that all the parties are interested in. Normally, the person, when they're served with a search warrant, once I get that search warrant, there's information on there where I could figure out who the U.S. attorney is. So I don't even have to contact the agent who served it. I can figure out who the U.S. attorney is on the case. And sometimes the U.S. attorney is not the one who signed the search warrant. They are actually doing it for a colleague in another state.
Mm.
So yeah, it's important to get involved so that the government has somebody to speak to, like me, instead of my client, so we know where things are going. Where are we going? And I can also contact them so that we could make things easier for the client, so they're not they're home and their loved ones aren't awoken in the middle of the morning. It's time for court. Guns drawn. Where is he? Taken into the street. I can make it a lot easier. We can arrange a bond ahead of time, a date and a time to go to court and self-surrender. So there are certain things we could do if it's coming to that.
Sure. Well, finally, and related, what advice would you give to somebody or their family if they find out that a federal drug investigation has started?
Well, I would contact, a federal defense attorney like myself, and I will I have to figure out who we need to contact, and I'll contact them on your behalf. And I'll get a little information from the U.S. Attorney's Office, and then we will have a meeting, and I'll tell you what your options are. But it's something that you should do rather than, walk around in the dark, not knowing what's going to happen.
Right, for sure. Well, thank you, Robert, and thank you to our audience for joining us on Criminal Law Unfiltered with Robert M. Helfend. The stakes in federal drug cases are high, but the right defensive strategy can make a major difference. If you or a loved one are facing charges, visit robertmhelfend.com to schedule a consultation. And be sure to subscribe, leave a review, and share this episode so others can benefit from Robert's insight. Thank you, Robert.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.